Yes, I'm Jim Sensenbrenner from Wisconsin. I was the chair of the Judiciary Committee from 2001 to 2007. And unlike most of my colleagues up here, I have supported most of the free trade agreements that the United States has negotiated when they have come before Congress for ratification. However, the first-to-file system clearly violates the Constitution because it would award a patent to the winner of the race to the PTO and not the actual inventor who made the discovery. The court's early construction of the word inventor further indicates that the first to invent standard was the commonly understood meaning at the time of the Constitution's ratification. Let me give 4 examples. Chief Justice Marshall in 1813 explained that the law recognized a property right in the inventor, quote, from the moment of invention, unquote, which was, quote, only perfected by the patent. That's the case of Evans versus Jordan. In Pennock versus Dialogue, 1829, the Supreme Court opined that under the Constitution, the right is created by the invention and not by the patent. In 1833, the court held that, quote, it clearly appears, as was the intention of the legislature, by compliance with the requisite of the law, to vest the exclusive right in the inventor only. And in 1826, a New York district judge said that, quote, it is very true that the right to a patent belongs to him who is the first inventor, even before the patent is granted, unquote. That is, none but the first inventor can have a patent, further, unquote. Now let me go back to the history of the patent law. Early acts of Congress, often considered to be highly probative in constitutional intent. Because of the 55 delegates to the convention, 19 later served as senators and 13 as representatives. The first patent statutes strongly support the first to invent statute. The Patent Act of 1790, enacted in the second session of the first Congress, authorized the grant of a patent to one having, quote, invented or discovered any useful art, not before known or used, unquote, and provided for the repeal of a patent if it shall appear that the patentee was not the first and true inventor. The 1793 Patent Act also created the first interference provision, an administrative procedure for resolving competing claims to the same invention. In one of the best-known early cases involving 4 claimants to a steamboat patent, the Patent Board rejected the proposal that the patent should be awarded to the first person to file an application. Thomas Jefferson served as one of the members of the original Patent Board, and his role in the decision to reject the first to file approach gives added weight to history. Jefferson's influence on American patent law is very well established. Those of us who stand before you today are standing with Thomas Jefferson. We're standing with the framers of the Constitution. We're standing with the early court decisions interpreting the patent law of the Constitution. And everybody believes that first to invent gets the protection of the patent law, not the one who races to the PTO first. Now finally, most of the problems with the PTO, as has been referred to earlier by Congressman Rohrabacher, deal with the issue that there has been a huge diversion of patent fee funds into the general fund. Excuse my allergies. If we really want to solve the problem of the dysfunctionality of the patent office, we ought to pass a bill that ends this diversion, allows the patent office to keep its fees, and use those fees to improve the adjudication of patent applications. The bill's unconstitutional, it does the wrong thing, it doesn't solve the problems in the patent office, and unless it's amended to only deal with the fee diversion issue, it should be defeated. Thank you.
I like this constitutional debate going on is that
there's a bipartisan nature of it, which I welcome. But it's very rare that I have a bipartisan group working with me in which the Republicans outnumber the Democrats. It's only 3-2. So I'm here to support the principal arguments that have been made. There's another problem in this measure that bothered me. And before that, I should say that there was a certain stealthy speed in which this bill was supposed to have gotten through. It was whipped through one body, and it was supposed to get through the other body. And I feel very proud of the members of the Judiciary Committee who stopped long enough to say, oh, sure, we've got to move fast, but can we look at this a little more carefully? And I commend Mr. Rohrbacher and Marcy Kaptur for moving us along to the constitutional debate. But the bill also would allow the Patent Office to invalidate an approved business method patent, even though it may have already undergone numerous examinations, and could end up depriving a patent holder retroactively of rights that had already vested. It constitutes a taking of property by the government without just compensation. That's a constitutional violation. And that's why I'm here, and I will be looking forward to the debate. And you've only had 7 Supreme Court cases cited to you, so write down Landgraf, this is the 8th, Landgraf versus USI Film Products, and you'll see where my argument comes from. Thank you very much.
Thank you. Don Manzullo, then we're going to all have to run off and vote, I'm afraid.
I'm Don Manzullo from the 16th District of Illinois. Probably 75% of my work involves manufacturing. I'm one of the co-founders and co-chair of the Manufacturing Caucus. Our district has over 2,500 factories. As Chairman Sensenbrenner said, this is not an issue of people who voted for or against free trade agreements. Jim and I voted for all of them, and other folks up here have voted against all of them, with the exception of the Australian Free Trade Agreement. And so let's put that aside. Second of all, our present patent system is already compliant with the WTO. We're already harmonized. That issue has been debated. There's nothing wrong with our patent system. And so the issue here is, why do we want to harmonize with Europe? Portugal, Israel, Greece, Spain, those countries that don't know how to run a country, that are on the verge of bankruptcy, on the verge of the EU going under. Why would the United States want to become like the European Union? It simply does not make sense. There is no evidence that the European system is any better than the American system. There is no evidence the European system is any better than the American system, so why change? There's no necessity to do that. This is a bad bill. Oh, I'm sorry. I said Israel. I'm not Italy. Forgive me. Thank you for getting that straight. And I appreciate that intervention. This bill is bad for small and medium-sized manufacturers. Why? Because it takes away the grace period on the first to invent, so they can take that period of up to 1 year and raise capital that's absolutely necessary to do it. And whenever you harm the little guys, most inventions come from them anyway. And that's why organizations such as the National Small Business Association, which has a lot of small and medium-sized manufacturers as members, is adamantly opposed to this bill. And so, why add another layer of appeals? Why make it more complicated? Let me close my presentation with this. There was an article that came out in which we widely circulated on the last patent, this is my fourth one, by the Chinese Intellectual Property News, talking about the very system of post-grant review, but more importantly, talking about the right, the first to file versus the first to invent. And we have copies of that article. In the most poignant statement that you will find in that article is summarized by the fact that the Chinese are absolutely excited about the United States opening up their patent system, harmonizing it with Europe, and making it easier to steal the patents. We just had a hearing where Fellows, the world's largest shredders, was wiped out in China with $196 million in machine tool and property, intellectual property theft. The CBO came out of the Library of Congress just a couple of weeks ago. The Chinese are responsible for about $45 to $50 billion a year in American profits because they don't apply the rule of law. So why should we change our system to harmonize to Europe to make it easier for the Chinese to steal our patents?
We're going to have to go now. I apologize for just one last note. These major multinational corporations are motivated by what you'd expect them to be motivated by. What they can make, how much money they can make, and how successful they can be for their own company. We are not here to support multinational corporations. Government is here in the United States to support the rights of the individual. And in this case, these multinational corporations are trying to manipulate the process so they can smash small inventors like they're little bugs. And in doing so, they're trying to rip up the Constitution, but at the same time, they will destroy the competitiveness of the United States and throw Americans out of work. We're not going to let them get away with this. That's what this is all about. It's a fight for the American people for prosperity here, rather than having these multinational corporations alter our Constitution so that they can succeed while the rest of us fail. Thank you all very much.